So thank you very much. We can start right now with another session. So first of all, let me say that I'm very grateful to the organizers of this conference on domesticating international criminal justice. Both Chantal and Florian, very good friends and colleagues. So thank you very much for this opportunity to be here today with you, for inviting me to chair the next panel, which would be on the following topic: attribution of liability and grounds for exclusion of criminal liability. We will have, as usual, a certain number of panelists. Some of them are here, so they are very welcome. H.van Wilt, Volker Nerlich, and of course, Chantal Meloni. And two other colleagues will be connected remotely, and they will have the opportunity to take the floor as the previous one. So Anna Garrocho Salcedo and Georgia Stephanopolou. So thank you, everybody. And the topic we are going to discuss right now, you know, the format of the panel, which is always the same. There will be a main discussant, and that in this case will be Chantal herself. So thank you very much, Chantal. And then the other panelists will react to a certain number of topics which will be presented afterwards. We will follow, as usual, an alphabetical order. There will be no internal structure to be given. And I will personally just give some very brief introductory remarks, not more than 3-4 minutes. Chantal, allow me to do that. Don't look. You are the boss. Yeah, no, I'm not the boss. I just want to briefly introduce the topic, but no more than 3-4 minutes. That's what I will do. But first of all, we are now dealing with the general part of international criminal law. I think the order which has been given to the different topics deserves our attention. The idea was, of course, to deal before with the specific crimes and then with the general part. This is an interesting focus because it corresponds to the historical development, both of domestic and international criminal law. One of the points which has been highlighted in the presentation of these this panel by the organizers is whether or not we should consider to adopt in this area the general rules of criminal law, or if we should adopt specific rules, what is being called a twofold system. The organizers take a very clear stance in favor of the application of general rules. I think it's still an open debate. I'm not taking any time more, Chantal. I think that we'll deal with one of the most crucial issues related to the general part of international criminal law. I have to say that I'm glad to have such a panel of distinguished colleagues coming from different areas and countries, of course. I also have to say that, in my opinion, this area deserves an increasing attention, both theoretically and relating to the case law. I still see when I look at the case law, a very vague and confused and disputable area of law. I had the opportunity in the past to deal with some of the issues, and specifically with Article 25 of the ICC statute, but I wouldn't add anything more. I maybe will take the freedom to make some questions to our panelists afterwards. So Chantal, thank you very much.
Thank you very much, Stefano. As you already said, with this afternoon panel, we are moving from the discussion of the special part of International Criminal Court to the discussion of the general part of international criminal law and how to best implement it at the domestic level. And of course, I'm stating the obvious here, but we have to be aware of the different implications when dealing with the general rather than the special part of international criminal law in light of the different origins of the two parts. So while the special part, the crimes, are the core, the original, the kern of international criminal law, which finds its sources directly in international law. The same is not true for the general part, which, save exceptions, finds its sources in criminal law, domestic criminal laws, common general principles of criminal law. So as we all well know, for the first time, the Rome Statute of 1998 includes a comprehensive set of principles that on the general part that were absent in statutes of previous international criminal tribunals. As also already mentioned by Stefano, the preferred option would be not to duplicate the general part in implementing, domesticating international criminal law, but rather clarify that criminal law principles and rules apply also to crimes under international law. Thus, in hypothesis, the general part of the Italian criminal code could remain applicable to the international crimes, which is, as you already heard yesterday, the approach that has been taken by the German legislator, where it is stated in the Völkerstrafgesetzbuch that the general criminal law shall apply as far as not decided otherwise. Accordingly, the Völkerstrafgesetzbuch doesn't make any special provision as regards to most of the general principles contained in the Rome Statute, in particular articles 22 to 33 of the ICC statute, including the principle of legality, the minimum age for criminal responsibility, the relevance of official capacity, the mental element, grounds to exclude liability, insanity, duress, self-defense, mistake of law. So as regards to all these issues, the provisions of the General Criminal Code remain applicable. So the question is, when is decided otherwise? It is decided otherwise when a rethinking is needed vis-à-vis specific provisions of the general part in light of the specificity of crimes at stake, and this can happen basically in two scenarios. First, when the specific principles or rules of international criminal law are not regulated in ordinary criminal law, or when the deviations are necessary to meet the standards of international criminal law. So the few, again, to make a brief reference to the German code, the few special provisions included there relate to the responsibility of military commanders and other superiors, the absence of statutory limitation for crimes against international law, and obedience to superior order. In Italy, I would say that the question arises in particular and also with regard to the rule on attribution. We are all well aware of the debate around the need to develop specific modes of liability for international crimes. The first time, the Rome Statute, again, for the first time provided for a detailed set of rules on attribution. In particular, these are contained in Article 25 of Paragraph 3 of the Rome Statute and Article 28. And in the past, almost now 20 years of activity of the court, the judges have redefined the theories around the attribution and the modes of liability, and there is now a fairly rich case law on some modes of liability at least. I am thinking in particular of the mode of liability of perpetration, which in turn includes three forms: co-perpetration, indirect perpetration, and the co-perpetration as an individual. And these, the same maybe is not true with regard to other modes of liability that were less focused in the ICC jurisprudence. For instance, other forms of participation in the statute received less attention, like aiding and abetting, and also paragraph D of Article 25.3. But in particular, with regard to Article 28, command responsibility, there is certainly much confusion still around its elements and interpretation, and I will talk about this in a minute. I first would like to focus on the co-perpetration, the mode of liability under Article 25.3a, which, as stated by the judges of the ICC, contains the gravest modes of liability, perpetration, commission in its three forms. And the ICC judges from the Lubanga case, attenzione a non morire, onwards, have elaborated and have specified the details of these forms of perpetration, in particular, again, through reference to the German doctrine. And what was used is the German doctrine of Professor Klaus Roxin, Täterschaft, or Täterschaft, where it can be adapted that the legal theories at the basis of what is now called control over the crime approach at the ICC were based on this original idea by Professor Roxin, although, of course, then the approach of the judges departed to some extent from the original version. So the judges themselves, and here I quote, they said, the control over the crime approach has been applied in a number of legal systems and is widely recognized in legal doctrine. And in particular, they refer to mittelbare Täterschaft, indirect perpetration through the control over the apparatus. So this control over the crime approach adopted by the ICC, as I was said, of course, in part departed from the original idea of Professor Roxin, who, by the way, felt to intervene at a certain point in the debate, even replied to an article. I'm turning to Stefano because we were writing about his theory and the interpretation given to him, to his theory, and even replied to that. And it's now beyond the scope of this short panel to go into this debate, but what I would like to say, the bottom line, is that how the Article 25.3 of the Rome Statute is interpreted at the ICC, and even before that, how this article was drafted is strongly influenced by the German doctrine on criminal participation, which follows a differentiated approach. So through the domination over an organizational apparatus, Organisationsherrschaft, and Roxin dogmatic on indirect perpetration through control over the apparatus, it is possible to establish parallel responsibility of the two levels, namely the leader and the subordinate, respectively, as indirect and direct perpetrator of the crime, where the direct perpetrator and the indirect perpetrator are both guilty and capable of being punished for the same offense. And clearly, again, this is coherent with an understanding of criminal participation based on a very distinct and sharply differentiated model. There have been pushbacks on this, both in scholarship and at the court. I am referring in particular to Judge Fulford, of course, the former ICC British judge, who wrote some interesting dissenting opinions, making the point that the differentiated model of participation was overcomplicating things, and that an alternative reading of the Rome Statute was possible based on a unified perpetrator model. On the same lines, Professor James Stewart from Canada spoke about the end of modes of liability in an article, The Sparkle Debate, a few years ago. Indeed, the unified perpetrator model presents some immediate advantages, at least at the attribution level, simplifying the burden of proof on the prosecutor with regard to the elements of the modes of liability. However, and we have to be aware of this, the same problems ultimately surface again So at the sentencing level, when there is a need to differentiate among the various contributions and the gravity of the conduct and the individual culpability need to be established. In Italy, where the criminal code provides for a unified perpetrator model of criminal participation under Article 110 of the and following of the Italian Criminal Code, person to which everyone who participates in the crime is responsible for the crime itself, there is an endless debate among criminal scholars. Over the years, many projects of reform have been submitted to overcome this model. Now, with an eye on the project of domestic implementation, the questions specifically regarding the rules of attribution with specific reference to the Commission of International Crimes is whether a system like the Italian one, which includes a very broad clause of participation pursuant to Article 110 of the Criminal Code, would be appropriate and able to encompass the provisions of the Rome Statute. And again, oversimplifying in these brief notes, I don't see major obstacles in this sense. At least letters A, B, and C of Article 25.3 can be included. Not everything is clear about letter D, which in some way resembles the joint criminal enterprise of the ad hoc tribunals, yet the joint criminal enterprise was not accepted at the ICC, was declared to be not part of customary law. And as far as the Italian system is concerned, many of these scenarios that are around joint criminal enterprise and this form of group participation in a crime are often punished through specific offenses of criminal association rather than in application of the general rules on criminal participation. Therefore, the question can be asked whether it would be maybe thinkable, appropriate to intervene on this level, imagining, for instance, the introduction of specific crimes of criminal association for the commission of international crimes. And I now turn to some brief remarks on command responsibility, which is, of course, the main missing point. And this is not surprising because it's explained exactly by what I was saying at the beginning. Very simply, this is an original creation of international criminal law derived first from the military sphere, then international humanitarian law, and finally it was taken by the ad hoc tribunals and it became a rule of international criminal law. And with the ad hoc tribunals, for the first time in the 90s, it became also applicable to the civil sphere. In the Rome Statute, for the first time, it is made clear that command responsibility, so better called superior responsibility, can be applied both to military commanders and to non-military commanders, which already we find some difficulties in defining who they are. We say non-military commanders, so civilians, which of course was a very welcomed step forward, but the reality is that it continues to be incredibly difficult to bring charges against non-military commanders under Article 28, and also with regard to military commanders, actually it has proven exceptionally difficult to apply Article 28 and have successful prosecutions based on Article 28 of the Rome Statute, and the case of Bemba, I think, speaks for itself. Already in 2010, when I was closing my book on command responsibility, it was possible to observe that there was something that I had called at the time an erosion of command responsibility, meaning that this mode of liability was not used anymore by the prosecutor of the ad hoc tribunals, eroded by the joint criminal enterprise and other easier modes of liability that were exactly more handily also for the prosecutor. And at the ICC, I would say that the situation became even worse as it became too complicated to establish this responsibility of superiors, which is a pity in my view, because I strongly believe that command responsibility has its place and an important role to play in the international criminal law, both at the punishment, but also at the preventive level. The reason of this complexity are to a certain extent obvious and are those related to the assessment of individual criminal responsibility for omission. In Italy, commission by omission is well accepted principle in criminal law. We have a general clause of equivalence contained in Article 42nd paragraph of the Criminal Code. Something similar is in Section 13 of the German Criminal Code. But this is not the case in many other jurisdictions. There are several states also in Europe who do not have a general clause for omission and commission through omission in their criminal law. And there is more than that about the difficulties to establish this mode of liability. The problem with command responsibility as it is contained in Article 28 of the Rome Statute is that it conflated in one single provision different types of liability that cannot be treated in the same way. So following a thorough analysis that I, of course, will not repeat here, my conclusion is that following this analysis of the different subjective and objective elements of command responsibility as codified, let's say, in Article 28 of the Rome Statute, there are four modes, forms of command responsibility. Intentional failure to prevent, negligent failure to prevent, intentional failure to punish, negligent failure to punish. And not all of them are modes of liability. While the failure to prevent can integrate a commission by omission, and negligent failure to prevent can amount to participation in the crime of the subordinate, at least in Italy, according to our common rules, general rules, the failure to punish, which are responsibilities ex post, can only in our system be framed as the dereliction of duty offense. In this sense, I think the Völkerstrafgesetzbuch again is a good model, and the way it was done there is that Article 28 of the ICC statute was split in three separate provisions. One has been introduced in Section 4 of the general part of the Code of Crimes under International Law, which provides that a superior who is vested with the appropriate supervisory powers and does not hinder a subordinate from the commission of genocide, a crime against humanity, or a war crime shall be punished like a perpetrator of the offense committed by the subordinate. And then there is Section 13, which is a separate crime of dereliction of duty, the infringement of supervisory duties, taking into account varying degrees of guilt. And Section 14, which provides for the punishment of a superior for the non-reporting of a crime against international law committed by a subordinate. So in the last minute I will just mention that, of course, when we are talking about issues regarding attribution, as already emerged yesterday in the discussion, we should also reflect on the opportunity to include corporate liability, because at this point of the discussion, it is clear that not only individual persons, but possibly also legal entities, corporations that can be actors. Although the Rome Statute does not provide for the criminal liability of corporate actors, the debate is well present in international criminal law at the moment, and some countries have a legislation that permits to charge corporate actors for the commission of international crimes. Maria was mentioning this morning the Lafarge case, very important in France. It is about a cement factory charged with complicity in the commission of crimes against humanity for its conduct in Syria. And Professor Jesberger, many years ago, you wrote maybe the most important article on, of course, how Nuremberg, already at Nuremberg, organizations were criminally responsible for the crimes committed during the Second World War. So I will conclude here just saying that given the growing awareness regarding the role of corporate actors in the commission of international crimes, the question can be asked whether the domestic implementation at this later stage can be the opportunity for a rethinking in this direction, thus expanding the criminal liability for the commission and participation in international crimes also to corporate actors and organizations. And some suggestions already came yesterday from, for instance, Luigi Fofani in this regard. Thank you for the attention.
Thank you very much, Chantal, for this very rich overview. Well, and for sticking so perfectly with the timeline. So your 20 minutes. I will refrain from any comments, even if I would have a lot of questions for you, because you put on the table so many issues, diverse and complex, that I hope we will have the time to discuss all together at the end of this panel. I will ask Professor Anna Garrocho Salcedo if she's connected. She's supposed to be the first colleague to take the floor after Chantal. Could you please confirm?
Yes, I confirm. Do you hear me?
Perfectly, thank you so much.
Really? Okay. And do you see also my presentation?
We don't see you, we see your slides perfectly again.
Thank you.
Thank you so much.
Thank you, Professor Manacorda. So, thank you very much, Professor Meloni, Professor H.van, Maria Gripa, Professor Stefano Manacorda for inviting me. And thank you to all the organizers of this wonderful Congress, because I know there is a hard work on it. It's an honor for me to participate in this Congress and in this panel composed of so many admired colleagues. And well, as we have divided the work of our interventions, I'm going to focus on superior responsibility, a topic that was the subject of my doctoral thesis now some years ago. So, sorry, I need to up. Yes. So before going into the problem of superior responsibility, I could like to clarify very briefly how Spain has harmonized our law with the Rome Statute. First, Spain has carried out three major reforms to harmonize our criminal law with the Rome Statute. First of all, a criminal reform was carried out in November 2003, where crimes against humanity were included for the first time in our legal system, and the wording of the war crimes was reworded. The crime of genocide was in our legal systems in 1973, and the crime of aggression at the moment remains unregulated between us. Also, in November of 2003, superior responsibility was included as a special norm in Article 615 bis, and also it was declared the imprescriptibility of international crimes and the lack of any effect of justification for action carried out by virtue of orders to commit genocide or crimes against humanity. The second reform, as you can see, was in December, so all the reforms were from autumn, and in December of 2003, we made a reform of the procedural part, so we said, no, the organic law on cooperation with the ICC. As you see, this, okay, I have not many times, so I cannot detail in these details, but also you have to take into consideration. And thirdly, in October in 2015, which solved the problem of immunities from jurisdiction in cases of international crimes. So it was declared that no immunities over international crimes were permitted in Spain. This is theoretically because the practice is completely different. So we have no cases at the moment in our tribunals with these international crimes. Well, before outlining the regulation of command responsibility in Spain, I would like to put forward my position on the nature and scope of Article 28 of Rome Statutes. In my opinion, let's check if I can pass. Voila, no, not pass, not pass. Sorry, I'm sorry. Oops, yeah, sorry. So, in my opinion, Article 28 of Rome Statutes regulates a specific commission by omission where the core of the responsibility consists in the imputation of the crimes committed by a subordinate to the superior who doesn't prevent them in accordance with his duty. This is so in view of the heading of the precept, which expressly states that superiors are responsible for the crimes of their subordinates. And so has been done in Bemba case. So the charges were rapes, murders, and so on. But however, the majority of the scholars, between us, Chantal Meloni and Volker Nerlich, consider that there are several omissions present in Article 28. On the one hand, as it was said before, we would have a commission by omission in cases of omission to prevent crimes when they have not yet been committed. And also, on the other hand, we would have an omission to repress or an omission to submit the matter to the authorities when the crimes have already been committed in a manner of a pure omission and without the possibility, of course, of charging the crimes because it's an ex post facto intervention. However, I believe that there is room for an integrated interpretation of the duties of repression and report as part of a commission by omission and not as a pure ex post facto omission. So to this end, the first thing I would like to draw attention to is that regulation in Article 28 is totally different from Article 7.3 from ICTY Statute in relation to the temporal moment in which the duties are established. Thus, Article 7.3 from ICTY Statute mentions that the duties of superiors are triggered when the crimes were about to commit such crimes or had done so. So it's like present and past crimes. Whereas in Article 28 of Rome Statute, the wording of the rule makes it explicit that such duties arise in relation to crimes that the subordinates were committing or are about to commit. That is, the crimes have not yet been committed, completed, no? And therefore they can still be avoided. In my opinion, and taking into account the phenomenology of international crimes, the duties of superiors to act should serve in any case as a means of avoiding crimes that have not yet been completed or committed, no? So they can still be avoided. Yeah. So to this end, as you can see in the slide, the interpretation I propose for Article 28 is that the legal nature of command responsibility contemplates a legally determined commission by omission where all the duties indicated, so prevention, repression, or submission the matter to the authorities, are possible ways of avoiding crimes. This leads, in my opinion, to a compatibilist interpretation of Article 28 as a specific, as said, commission by omission. The example is as follows, no? Imagine we have some crimes, no? Crimes against humanity or war crimes, but they are not committed in one day, in one single day. So the crimes are divided in several moments where they are committed. So imagine that on day one, the forces of a military detachment kill 3 prisoners of war and torture 3 other individuals. the military commander becomes aware of the facts when the crimes have already been committed. And in this context, the superior does nothing, neither repress nor takes disciplinary measures nor denounce what has happened. As a result of his inaction, and given the probability of repetition, the same military detachment kills other prisoners and tortures other individuals again on day 2. In that case, the superior's omission could be connected with the crimes committed on day 2, as he was aware of the high risk of repetition of the crime, and yet he didn't take any action as soon as he knew, he became aware of the risk. So on successive days, the same criminal pattern is repeated by his subordinates and the superior remains inactive. In my opinion, the crimes that occur on days 2 and on days 3 are perfectly imputable to the superior, since knowing the serious risk of repetition, he didn't take any measures to prevent further crimes by repressing or denouncing or whatever. So they should take any kind of actions to avoid the crimes. The imputation of the crimes on day 2 and 3 does not violate the principle of culpability, nor is disproportionate. Here, we don't have a real threat of a illiberal excess, so that could be the point. It should be borne in mind that when a superior doesn't repress past crimes or doesn't denounce them properly, he is, by his omission, tolerating crimes that may occur in the future, and that if these new crimes are committed, they can be imputed to the superior who has not prevented them properly in a manner contrary to his duty as guarantor. So in addition to this, I would like to question the convenience of the ICC prosecuting crimes of pure omission after the crimes have already been committed. Moreover, in view of the mens rea provided in Article 28, it could make, in my opinion, of course, little sense to punish crimes of pure omissions by negligence. And, well, how is that? Yeah, okay. And finally, I present you our Spanish regulation on superior responsibility in Article 615 bis of the Spanish Criminal Code. So here, as you can see, we have 3 different omissions of different scope and seriousness. We can see. On the one hand, the article regulates a commission by omission, especially regulated when superiors don't avoid with intent or negligence the crimes of the subordinate. And as you can see, the penalty is the same as the perpetrators of the crimes. So it's very close, this part of the article, to the Völkerstrafgesetzbuch. But also in the same article, we have other 2 omissions, no? So secondly, we have this special pure omission of superiors, where it's criminalized the situation where the superior does not prosecute the crimes of their inferiors once they have already been committed. In that sense, they are contemplating an ex post facto intervention. Although, as you see, the penalty is quite high. I have to note this point because it's quite strange, but so it is. And finally, you know, Spain is different, and we have another kind of crime of omission for civil servant or other authorities. I think that they are thinking in judicial authorities that don't promote the prosecution of international crimes. In that case, the offense receives a penalty of disqualification from public employment from 2 to 6 years. No? In this case, note how Spain goes very far beyond the provision of the Rome Statute, and the judicial authorities in Spain could be have problems with justice if they doesn't promote the prosecution of international crimes. But, well, in sum, the fact that national legislation seek to prosecute omissions of lesser gravity does not prejudge the legal nature of Article 28, bearing in mind also the preamble of the ICC Statute, which strongly emphasized that the most serious crimes must not go unpunished. And I'm not sure that this kind of pure omissions should be persecuted for the ICC. So I think I'm finished, and thank you very much for your attention, and I remain at your disposal for the debate. Thank you.
Thank you very much to Professor Ana Maria Garrocho Salcedo. That I should have introduced by saying that she's Professor of Criminal Law at University Carlos III de Madrid. And thank you for summarizing in such a short time such a complex topic, and thank you for your insight. We have now the pleasure to give the floor to Nerlich, which is head of Chambers staff at ACC and honorary professor at Humboldt University. Thank you, Volker. You have the floor.
Thanks very much, Stefano, and thank you, Chantal and Florian, for having invited me to this very interesting conference. I've really been enjoying it so far, and I look forward to what remains of the conference. The subject of the conference is obviously the implementation or domestication of international crimes into domestic law. But with your permission, I would like to shift the focus a little bit. And as Chantal was saying, for the general part, it's a bit of a different direction almost in which things go, in that international courts and tribunals had to look very much into domestic practices to develop the general part, and that was simply because there wasn't any until the Rome Statute was adopted. There were only very few basic fundamental rules in the founding instruments of IMT, IMTFE, ICTY, and so forth. So in order to actually be able to adjudicate these crimes that were established, the international courts and tribunals had to look at domestic law. What I would like to do is to take one example, the example of the judgment of the Supreme Court Chamber of the Extraordinary Chambers in the Courts of Cambodia in the case 00201, which is the case against Nguyen Chea and Kyo Sampan, who were found guilty inter alia for the evacuation of Phnom Penh in 1975. And I would like to pick out a few methodological challenges that arose in this case, but it's actually only just an example. You could probably pick pretty much any international case, I would say pre-ICC, because the ICC has its own challenges in interpret, but it, as Chantal was saying, it has a relatively developed general part. I should also say that I'm speaking in my personal capacity, so whatever I say cannot be attributed to the ICC. I think one of the things that have troubled me from time to time when working as an international or in an international court is the question of what law are we actually applying. That's probably a question that doesn't really arise in the domestic context so much, but in international law, that is still a question. And for the crimes, it's relatively straightforward. You have conventions, Geneva Conventions, Hague Regulations, statutes of the courts and tribunals and so forth. And probably all these crimes are, or most of these crimes that are set out there are also somehow part of customary law. For The general part, however, I think it's not so straightforward. And if you're looking at the classical sources of law and international law, if we don't have conventional law, we may be looking at customary international law, or general principles of domestic law. Now, in this case, before the Supreme Court chamber at the ECCC, one of the questions the chamber had to address was whether and to what extent joint criminal enterprise actually formed part of the law in 1975. And as you will know, this notion of joint criminal enterprise was first identified by the ICTY Appeals Chamber in the Tadic case. It gives rise to liability for crimes committed in the context of a shared common purpose that amounted to or involved the commission of crimes, and the accused person must have participated in this common purpose. Now, the first question for the Supreme Court chamber was, do we look at general principles of domestic law or customary international law? And the Supreme Court chamber found, okay, for us, the basis is customary law, which is, I think, in line with other findings, in particular of the ICTY and ICTR. There's a bit of confusion there sometimes, but I think generally the approach is customary law. Now, the first challenge is obviously traditionally customary law regulates relationships between states, whereas here we're looking at essentially the relationship between a state or suprastate, an institution, and an individual. And the chamber sought to overcome that challenge by saying, okay, we are only interested when we're looking for state practice and opinio juris in cases that have somehow an international element. And that meant, in practice, that the chamber was looking at cases that related to crimes committed in the context of the Second World War. The chamber specifically did not look at other domestic practice for want of an international element. That approach, in a sense, seems to be persuasive. You need to somehow decide which cases are international cases. But I think if we are thinking about it a little bit more in detail, there are also a few challenges here. Because if we are looking at these cases that the Supreme Court chamber relied upon, they were mostly military tribunals, military commissions from American military, British military, Australian military, a few other courts. And these cases, or these courts, to the extent that we know, sometimes we know very little about these cases, in fact, applied their own domestic general part. And I think methodologically that raises a bit of a challenge in that one can say, okay, but this means that it was perhaps just a bit of pure chance or coincidence which rules of the general part they were applying. If it was a French court, they would be applying French notions. If it was an American court, they would be applying American notions. And then to say this is now our basis for identifying state practice and opinio juris for the general part at the international level, it may very well be right, but it is a bit surprising perhaps. The other challenge that the Supreme Court chamber faced, and was essentially directly linked to its approach more generally, was there was a cacophony of terminology in the sources. Actually, one of the points the defense had raised in this case was that these elements that the Tadic Appeals Chamber at the ICTY had identified are nowhere to be found anywhere in the cases relied upon. And that's true. The precise terminology was not used. The chamber tried to overcome that in my view, with a very interesting approach, namely by saying we are actually not interested so much in the terminology that was used in these World War II cases, but we were looking at the factual scenarios and whether they gave rise to criminal responsibility. So in the context of JCE, it was essentially to see where people found guilty of crimes in which were somehow committed by a group of people and where the individual accused was not carrying out the incriminated acts him or herself. So essentially taking a step back and looking, okay, now what did this give rise to criminal liability? So looking at the bigger picture. Also specifically not saying was this now liability as a principal perpetrator or as an aider and abettor or anything. The chamber said we are not interested in that, just the bigger picture. The Supreme Court chamber took a similar approach, and I'm mentioning this because it relates to another part of the general part. When looking at the mens rea element for murder as a crime against humanity. And here the question that came up was whether the notion, what we call in Germany and in some other jurisdictions, dolus eventualis, was included in the crime of murder, or whether you needed only direct intent. Again, the chamber surveyed a number of jurisdictions and again, essentially deliberately decided to ignore the terminology and said, we are not looking at murder or meurtre or whatever this translation may be, but rather whether in various jurisdictions it is possible to convict somebody of not more than negligent killing, if you want, in a case where there was no direct intent in the way we would be understanding it in German. Not that the German reference would be not relevant, but just so that we are on the same page here. Now, the additional complication here was that if you look at various jurisdictions, the concept of mens rea and how the various forms of intent are interpreted are not uniform. Yeah, there are very different concepts between the civil law world and the common law world, but even within these worlds, there are different ways of how to structure intent, what is important, what is not important, and so forth. So it was again necessary for the chamber to look at, to take a step back and see more generally what would give rise to criminal liability and what wouldn't. If you're now putting all of this together, this makes then the whole matter even more complicated. Because another question that the chamber had to decide whether the notion of joint criminal and the extended form of joint criminal enterprise 3, was included by customary law. The chamber concluded on the basis of a review of the case law of the post-World War II cases that it wasn't. But in a sense, this was the consequences of this for the purposes of the ECCC were limited or attenuated by the fact that the chamber had previously found that murder as a crime against humanity could be committed with dolus eventualis. And this, in a sense, meant that factual scenarios that at the ICTY and ICTR would probably have been covered by JCE 3, at the ECCC would be covered by JCE 1, as long as the crime of murder was concerned. I'm mentioning this only because it just demonstrates how complicated these things are, and that it is probably necessary to look at the broader picture, not just as saying, okay, what is the mode of liability, blah, blah, what is the mode of intent, but these things need to be sort of analyzed and thought together in order to really properly understand what is actually happening. And then, of course, the principle of legal certainty and so forth, which has been mentioned several times, could probably also be part of this discussion. And I very much look forward to hearing your views in this. Thanks very much.
Thank you again. It was very enriching in my view, having some inputs on the general rules of the general part, which are currently related to that. So mens rea, but also maybe causation should be taken into account when we talk about modes of liability. It's an issue that is underlying, and I hope we will be able to come back to this point during our debate. I would be, now I hope that Professor Georgia Stephanopolou, she's connected, she should be remotely connected. Can you confirm that?
Yes, I confirm it.
Thank you very much. So we are happy to have another colleague currently working from Germany, and she's now Georgia. She's she's postdoc researcher at the University of Hannover. And Georgia, you have the floor. Thank you very much. I would please ask our panelists to be very compliant with the timeline, because unfortunately we're short of time. And I'm sorry for interrupting some of you during your presentations, but I've been asked by the organizers to be tough on that. Thank you very much.
I give my best. Thank you, Professor Manacorda. Thank you very much, Florian and Chantal, for inviting me to this conference. I would like to develop two theses in this presentation. First, I would like to use the term hybridization to describe the shape and functioning of the general part in international criminal law, because I believe it best captures the subject descriptively. Second, I would like to turn the descriptive concept of hybridization normatively, in the sense that hybridization is not only descriptively, but also normatively the best concept for a general part of international criminal law, because it is best suited to combine legal certainty and justice. Legal certainty in the sense of linking legal reasoning back to familiar and proven rules of attribution. Justice in the sense that legal reasoning remains open to development for new constellations and cases in which the traditional instruments are not longer sufficient to reach just and reasonable results. For some time, there has been talk of increasing nationalization and growing fragmentation of international criminal law. With regard to nationalization, reference is made to the fact that states are adapting their criminal law to the substantive international criminal law of the ICC statute. This is said to lead to the so-called vertical fragmentation of international criminal law. The process of fragmentation seems to have a negative connotation rather than a positive one. The negative connotation is probably already inherent in the term fragmentation itself, which indicates non-transparency and confusion. In my opinion, one should abstain from this critical view of the increased implementation of international criminal law in domestic legal systems, and see the new phenomena not as a questionable mixture, but as an expression of legal pluralism. The notion of legal pluralism allows us to grasp and analyze the new trends in an unbiased manner without immediately thinking of the problems created by domestic implementation. This unbiasedness makes it possible to better assess the new developments phenomenologically. In my view, the nationalization of international criminal law and the resulting vertical legal pluralism are aspects of a hybridization process in international criminal law that is subordinate to this phenomena. Hybridization has so far been discussed predominantly in connection with institutional mergers rather than with a confluence of legal institutions of different origins and the merging of different legal rationalities. The establishment of national international criminal courts and the special chambers is in the foreground here. Another, no less significant form of hybridization, however, is the implementation of international criminal law in domestic law, often in the form of a reference to a country's own legal rules when a special regulation is not necessary. The legal pluralism that accompanies the nationalization of international criminal law should not be understood as a phenomenon in which different legal systems and enforcement mechanisms coexist in isolation from one another, rather as the legal sociologist Gunter Teubner shows in his theory of global constitutionalism, it implies that conflict of law rules emerge, which in turn give rise to hybridized law. According to Teubner, a legal pluralist approach allows by all means a compromise between sensitivity to regional cultural particularities and the operationality of modern law. The result is the emergence of a forum in which differences of various legal traditions and legal conceptions are discussed and worked on. Here, a double-voiced hybridity comes about, that is, mixtures emerge while differences and systemic peculiarities are maintained. The term double-voiced, by the way, comes from Indian post-colonial theorist Homi Bhabha, who can be regarded as one of the leading voices in the modern discourse on hybridity. A prominent example of this is the inclusion of a dogmatic figure of superior responsibility in the German International Criminal Code. The figure is an original creation of law under international criminal law, which underwent a broad diversification and elaboration during its implementation in German criminal law. However, hybridization does not only occur when special provisions are made for individual constellations. Another hybridization channel runs through the direct application of national general criminal law to regulate the general part of international criminal law. Domestic legal thinking flows directly into the application of the individual elements of international criminal law, which by their origin constitute supranational law. This allows the legal argumentation to be tied back to familiar and proven rules of attribution. At the same time, however, the openness to development is ensured by the development of special provisions of a hybrid nature for constellations and cases in which the traditional instruments are no longer sufficient. An implementation model that dispenses with familiar attribution figures of national law and designs new dogmatic constructs of its own, which are to apply to both national and international prosecution of crimes under international law, may offer legal certainty in formal sense, but may lose flexibility and adaptive dynamics. Such a rigid model may also lose acceptance as it lacks sensitivity to legal cultural specificities. Compromise is a constitutive element not only of international diplomacy, but also of international criminal law. Successful enforcement of international criminal law requires an open and pragmatic practice. The legal pragmatism which is needed here is ensured by the current solution of the German legislator and other current implementation solutions, which basically refer to the national rules of attribution and at the same time allow exceptions for special constellations. Moreover, this solution is most compatible with the principle of complementarity, according to which state prosecution takes precedence. State sovereignty is thus given great importance. Seen from this perspective, the inclusion of domestic legal regulation in the implementation of international criminal law should be understood as a further expression of the primacy of indirect enforcement of international criminal law. The complementarity principle has not only formal implications in relation to the question of jurisdiction, but also substantive meaning. It calls for the active co-creation of substantive international criminal law by states as an expression of their sovereignty. To sum up, I believe that the practice of referring to domestic general criminal law while introducing special provisions when necessary is a solution that can mobilize the productive forces of legal pluralism, hybridization, and legal pragmatism. It also necessarily results from the need for legal political compromise that prevails in international criminal law. A flexible, open international criminal law that makes use of familiar attribution structures can gain in acceptance and assertiveness. Finally, indirect enforcement of international criminal law, which takes precedence over direct enforcement under the complementarity principle, is also reinforced by this pragmatic and pluralistic approach. Thank you very much for your attention.
Thank you very much, Georgia, for mentioning this theoretical framework and the idea of flexibility and pluralism. I think it was an important piece of our discussion, and I'm now happy to give the floor to Professor H.van Wilt, who is full professor of international criminal law at the Faculty of Law of the University of Amsterdam, and of course, as the previous panelist, a very well-known expert in this area. Thank you.
Thank you very much, Mr. Chairman. I would like to take the opportunity to thank the organizers for their warm reception in many respects. This is really great. What will I do this afternoon? I will try to explore the boundaries between terrorist offenses and war crimes. And you may question, well, what has this to do with the modes of liability? Well, don't be concerned, because I will try to explain. I will briefly address recent Dutch case law in respect of participation in a terrorist organization. So I'm looking through the prism of the participation in an organization in order to address the blurring differences between war crimes and terrorism. Well, participation in a terrorist organization, it will not surprise you, is a criminal offense in Holland, Article 140A of the Dutch Penal Code. When does one incur criminal responsibility? Well, borrowing from the provision on participation in a criminal organization, Article 140, the Supreme Court has identified a number of elements. There must be a durable, steady, not short-lived collaboration within an organized structure, and the accused must belong to that organizational group. The organization must have the intention to commit terrorist offenses. The accused must have some contribution in furthering the organization's objective. I was already speaking a bit German, because you will notice that this is not revolutionary. You have the same construction in France. You have l'organisation des malfaiteurs, and I guess that in Italy you will have a similar construction, more or less. So that final element, the accused must have some contribution in furthering the organization's objectives, is pretty vague, because it can encompass almost anything, as was confirmed by the Dutch Supreme Court. So it's one of the three issues that I wish to briefly discuss with you, because they raise some concerns from a legal point of view. Do not be afraid that I will be too verbose, because the other issues are directly connected. So first, the contribution to the criminal organization's purpose. In a very recent case, this September, no, it's October now, yes, that's the previous month, September, a district court of Rotterdam, the accused was charged with participating in a terrorist organization of Jabhat al-Nusra. And that is, as you may know, is closely affiliated to Al-Qaeda. He was apparently one of the big shots of the organization, had close contact with other high-placed persons, and had avowed that he thoroughly hated the regime of Assad. Now, he might not be singular in this respect, because there may be a number of persons here in this room that share this hatred. All right, but what did he actually do? The court emphasizes again that he occupied a leadership position and added that such persons have a duty to restrain the conduct of other combatants. But that is rather general and pretty gratuit. There is no mentioning of a superior subordinate responsibility and relationship. Apparently, he has been present during the commission of violent acts by the terrorist group, and that would suffice for accepting aiding and abetting, provided that it could be qualified and interpreted as encouragement, referring to the Furungia case by the International Criminal Tribunal for the former Yugoslavia. Furthermore, he confessed that he had no problems watching movies, footage that revealed the killing of military of the government of Assad. He was sentenced to 15 years and 9 months. Another case by the same district court features a female accused who faced the same charges, so participation in terrorist organization. The proof that was adduced to sustain the charges included chats and Facebook pages on which she showed weapons and bomb belts. She clearly glorified the appalling violence committed by IS, traveled to the battle area, and by taking care of her children and supporting her husband, cooking, by doing household work, she facilitated the intentions of Islamic State. Even further removed from actually committing violent acts or furthering those acts was the lady that stood trial on account of an attempt to participate in a terrorist organization. What do we have to understand by an attempt to participate in a terrorist organization? She had learned Arabic and had immersed herself in the ideology of Islamic State. In ardent farewell letters to her parents and family, full of religious fervor, she confided them in telling that she wished to travel to Syria. However, she did not succeed in mission and got stuck in the border region between Turkey and Syria. She was convicted on the charges and sentenced to more than a year prison, a half year on probation. It's interesting to compare such rather inconspicuous contributions to another case in which the accused was acquitted for participation in a terrorist organization, although he had joined the organization Alal al-Sham that defended the village of the accused against the siege of Assad's army. While the Alal al-Sham was part of the Syrian Free Army that has been supported by the Dutch government, it had nonetheless been depicted as a terrorist organization that, according to the Dutch Supreme Court, deserved that qualification because it was bent on toppling and destroying the Assad regime. And that this is, of course, crucial, that this has expounded this notion of what is actually terrorism. Yet the accused's activities as a civilian guard and member of Alal al-Sham did not yield participation in a criminal organization. So the outcome of this case is slightly spurious and draws our attention to another aspect. What is a terrorist motive? Clearly, one would perhaps expect a trade-off between the actus reus and the mens rea. If the actus reus is conspicuous, you might economize on the mens rea, and the other way around. If you have a strong dedication to contribute to the final contribution, your terrorist motive, you could perhaps reduce a little bit on the actus reus. But that is not the case. there is a strong emphasis on motive. And we all know this, that in case of terrorism, there is a very strong emphasis on motive. It can be both the intimidation, the igniting fear, terrorization by violent means of a civilian population, and the aim to rebel against and destroy an institution of the state. And this is, of course, the result of this famous, well, I don't say, I'm not particularly critical on this particular outcome, the decision of the Lebanon tribunal, but because they were asked, our friend Salcedo was there to spur it, they were asked to figure out what the customary international law was. But we, of course, we are dealing here with this very bad general comprehensive convention on terrorism, which lumps the two together. Yes, it can be either igniting fear, which was the more classical way as we understand terrorism, or it can be bringing down the government. Well, if you accept this, that will be the complete demise of the political offense exception in extradition law, as we understand this. Yes, and that is a great problem. And I hope really that this comprehensive convention will never be adopted. And I think that we have very good reasons that it will not be, because the states do not concur, of course. So if we take this, in this case, the organization derives its terrorist label from the fact that it aimed to fight the Assad regime, yes? But he accused himself by merely defending himself against the Assad regime that suddenly was qualified as terrorist itself. So there's a very interesting reversal of the qualifications, did not harbor a terrorist motive. Now I'm confused, yes? Was that relevant for the legal question? One is tempted to wonder whether the outcome was not influenced by the Dutch sympathy for the cause of the organization in question. Yes, well, of course, this is a rather cynical remark, but I still wanted to make this. The third issue, how does participation in a criminal organization relate to war crimes that have or have not been committed in the context of that organization? Now, I would like to end on a positive note, because here we have a decision also recently, 16 July 2021, of the Court of Appeal of The Hague, addressed the criminal responsibility of a 49-year-old Syrian warrior who was charged both with committing a war crime and participating in a terrorist organization. Here you see the fusing of the two concepts. Committing a war crime within the context and by being a member of a terrorist organization. Interestingly, the court convicted the suspect on the first count, as it found the man guilty of being involved in a captured officer of the Syrian army. And that is, of course, definitely a war crime, because the victim enjoyed protection as a POW under common Article 3 of the Geneva Convention. However, the court acquitted the man of the charge of participation in a criminal organization. Interestingly, the court casted reliable doubt on whether the organization itself harbored a terrorist motive. It was engaged in a fight for life and death with the official Syrian army, and the act, though a war crime, was inspired by feelings of vengeance rather than pointing at terrorist intentions. In my view, this is the right thing to do. Well, I just close my brief comment. I gave a bird's eye view of a couple of very recent Dutch court cases. They shed an interesting and sometimes a bit confusing light on the interpretation of participation in a terrorist organization, casting the net rather wide. Of course, I acknowledge the dilemma. I, as fellow travelers, potentially present a considerable danger for society, and one should not underestimate the risks. Moreover, from a purely legal point of view, it may be difficult for courts to differentiate between the motives of individuals and the motives of organizations. However, one may wonder whether such a broad interpretation of participation does not exceed the limitations of attribution of criminal responsibility. Moreover, the real problem is in the conceptually elusive terrorist motive that encompasses such diverse inclinations and plans. And George Fletcher, he warned already 15 years ago. Yes, I have another topic, but I don't. I will not touch upon this. But he warned against the subjective inclinations in criminal law. Yes, that we all only emphasize on what goes on in our head. Now, we cannot assess this properly. We have to go by the deeds. Yes, and that is something that has been forgotten. So I added the final case because I wanted to end in a more positive tone, because it demonstrates that courts sometimes are mindful of legal distinctions and refinements. Although terrorism and war crimes often conflate, not all war criminals are simultaneously terrorists, and not terrorists are simultaneously war criminals. Thank you.
Thank you very much, Professor van der Wilt. Of course, we are here. We have another example of a dilatation of modes of criminal liability coming from national experience, domestic one, but look at international law. I feel that we are all quite frustrated because we have to ask all the panelists to be short on a certain number of topics that really deserve our attention. We have the time for having some debate right now and some questions for the audience. As I said, I refrain personally from making questions, even have a certain number of them for the panelists. Who is going to make the first question from the audience? Professor Pocard. You need a microphone.
It's not a question, actually, but a comment. We spoke of several, I'm grateful to the speakers. They took several issues, and one may have comments on all of them. But looking at the last interventions, there is a sort of discussion on the co-perpetration, JCE, and now we have also the organization. It's a fact that for international crimes, you need some solution for crimes committed by groups, because the commission, the perpetrator of international crime normally is not one person. There are more than one. In most cases, there may be an individual that individually commits the crime, but normally the crime is committed by a group of people. Now, if I take it from the point of view of the implementation of the statute in domestic legislation, I have some difficulties in a way what to choose. One can stick to the Rome statute, of course. This is the occasion is to adopt, to implement the Rome statute. One takes that as it is, does not change anything, and accept the reasoning of the ICC on it, the interpretation given by the ICC. This one way possible. But does it cover well situations like the terrorists? Like the crime of terror, except the war crime of terror, of course, is not included in the Rome statute for the time being. So it's an area that's still not covered. How will the court deal with that area? Because if I see the theory of the organization goes back to Nuremberg. It's exactly the theory of the London Agreement. You have a Nazi party. The Nazi party is a criminal organization. Participating in the activity of the organization is criminal, and that's it. That was, it was clearly said. You declare the organization criminal, all the courts military commissions, and so the domestic courts had to follow the idea that that organization was criminal, and hence participation in the organization is criminal. And it's what I see now with terrorism coming back in a way. All the theories that looked abandoned in a way. The comment is that, well, we can for the time being stick to the ICC statute. That would be a practical way, but I don't know whether in the future this will serve all the purposes actually. But I don't know if I got a red thread to the interventions.
Yeah, Jaime Couso. Yes, please.
Hello, good afternoon. I'm here in Chile. Happy to be again with you. I have a question maybe for Chantal, and perhaps Professor Van der Bilt would like to say something about it. A very interesting remark by Antonio Coco yesterday referred to one of the pros of this incorporation with amendments, and that's the possibility to drive a change in customary international law. And if we see at the prospect of Italian implementation of the Rome Statute, I'm wondering of a possible effect of driving a change in the importance of membership liability or collective liability. Italy has a very strong experience dealing with criminal organizations, and a doctrine on the participation in a criminal organization from the outside, the concorso esterno. So the possibility for a person who is not a member of the organization to be liable as either an arbiter. In Argentina and Chilean case law, when they come to the so-called second or third circle of liability, so trying to make accountable, for instance, business people, physicians, state officers, judges, evidentiary shortcomings and maybe high standards of substantive law in relation to co-perpetration and so on, has make prosecutors and tribunals to hold people accountable just as a member of a criminal organization. And in this context, so these developments of Italian doctrine and law on criminal organizations and the concorso esterno, yeah, could appear as interesting. But I'm wondering if you see the possibility of the some sort of revival of this collective or membership liability, and in the way of this change in customary international law, yeah, because of this interesting developments in Italian and some other countries' law. So that's my question. Thank you in advance.
Thank you. My question goes to Ana Maria Garrocho Salcedo. I very much liked the idea of this unified conception of command responsibility, also for Article 28 of the ICC statute. But I don't know if you alluded to this, but where would you put then the command responsibility within the broader concept or regulation of modes of participation? I mean, also with regard to this discussion on the hierarchy of blameworthiness, or in how would it fit in then with in comparison to I don't know, aiding and abetting, or Article 25(3)(d), for example. Thank you.
Shall we move maybe to the answers, and then we will see if there will be more time for some questions. Let me add one single remark, maybe to Chantal or to the other panelists. Well, of course, we are all aware that when we talk about collective dimension, we still talk about individual liability. So we want to be there. And my feeling is that some of the issues that have been mentioned, and maybe there were some echoes in the questions as well, are not that new to criminal law. I'm really wondering if we will have so many issues in translating into domestic criminal law, such a complex dimension. The question is much more related to interpretation and the role of judges. As far as Italy is concerned, of course, participation into a criminal organization and concorso esterno, something which has been mentioned by our colleague, is of course much more a matter of interpretation. And let me say that there were, in my view, more than this overestimating the debate among unitarian or differentiated model, the real issues, which are the elements that the judge has to find and motivate on when he wants to convict somebody. And the question is causation and mens rea. I'm oversimplifying. I don't really feel the debate about unitarian and differentiated model brought us really far away from the place where we were before. I've been very direct, and my question is whether or not you think that in the implementation we will be we won't encounter so many difficulties. The question will arise from the application, and the issues related to that are more causation and mens rea, as I think they are in the case law. So thank you, but I could not refrain myself from talking to the panelists. Chantal has the floor, Anna Maria has the floor, and the other panelists as well, but there were two questions which have been directly addressed to you, Chantal. One to Anna Maria, and of course the panelists will react. The other panelists will react. Yeah, okay, so for the Nerlich as a very short question for Anna Maria.
Yeah, just that I understand it correctly, under your concept, the superior would not be held responsible for the crimes committed on day one. I would just like to understand that better. Thanks.
Very short.
I have, okay.
Anna Maria, you have the floor if you want.
So it's my turn. Thank you very much for posing these interesting questions. So
I just ask you to be short. I'm not under Chantal pressure and the timeline, and I don't want to be in the position to be liable for that. So just let's try to be very short, and I think there will be more occasions than to
yes,
discuss on that.
Of course. Thank you, Stefano. So for me, the title of imputation of the superior are perpetrators. So since taking into consideration that the superior is the guarantor of the subordinates, they have to control the subordinates, for me, it's like the other side of the money, of the coin of perpetration. So that was my thesis, and I think that he cannot go a step forward. He is not an evader, so he is a central part of the crime. Is by omission, of course, but the title of imputation, in my theory or in my understanding, would be he has to be considered as perpetrator by omission, as we do in the business. So in the business chain of command in an enterprise. So in Spain, when someone is accused of a crime of omission in an enterprise, and he is the guarantor of the conducts of others, that they are not others, they are their inferiors. So this relationship between the inferiors and the superior permits, in my opinion, to impute the crime as perpetrator. So that could be my answer, Mr. Burkhardt.
Thank you very much for your answer. I think you underline something which is very important. Domestic criminal law usually deals with collective dimension of crimes, both in criminal organizations and business criminal law. If we forget that, we will probably forget an evolution that has been taking place in the last decades, and it is very present in the domestic debate. Chantal, it's your turn.
Yeah, I think going back to what Jaime was saying, of course, in Italy, if you want, we have a lot of provisions and we have a tradition, as you remembered, of dealing with group criminality, membership liability, and it's not a coincidence that the joint criminal enterprise at the ICTY in the Tadic case was under Professor Cassese. I don't know if he was the president or if he was the president of that chamber during the Tadic case, but I mean, he was an Italian coming with our frame of mind, which is very much into that direction. And I agree with Stefano that the same problems are to be found at the ordinary, so to say, common crimes, but definitely they are here brought to a next level. The issue of establishment of the nexus, causal nexus, the mens rea with regard to the participation in a criminal group, if already complicated that with regard to some group crimes at the domestic level become even more complicated at the international level. Here, there is something I remember, I think we discussed with Boris like 20 years ago, and for sure also with you, Stefano, and there have been attempts, in particular, I want to mention Professor Albrecht in Germany, but not only him, other criminologists and criminal lawyers, scholars in Germany in particular, that tried to develop or started to develop a specific comprehensive attribution doctrine with regard to crimes against international law, under international law, because there is the context element. This makes the whole difference. So if you have the attribution of individual criminal liability at the individual level, but then there is, of course, so we are still missing that. We are still missing a comprehensive doctrine in this regard.
Thank you. Thank you very much for recalling this doctrine. The question is, do we need that? I mean, but probably it will be the point of another debate or a conference. And Volker, do you want to react to some of the elements which have been put on the table?
Perhaps just 1 minute. I think it's absolutely right that we are not yet at the end of the journey. It's extremely difficult to capture these complex crime situations. And what we see with regard to membership in a terrorist organization, which indeed can be traced to membership in a criminal organization, it's essentially a way to deal also with the factual problems. With the evidential problems, it's much easier to prove that somebody was a member of something than that he or she actually did something, and that this led to something. And that's, at the end of the day, then a question of criminal policy, in a sense. If one wants to go down this route, there will be limits dictated by principles, but I think one should not throw that out so easily, because at the end of the day, the criminal law must also be able to react and address these highly complex forms of liability, criminality rather, and the tools that have been developed for much less complex crimes may simply not fit.
Thank you. Maybe you were also underlying that we were missing a common lawyer at this table, putting that, say there was more a problem of evidence than a problem of dogmatic structure, which I think is only partially true. But I mean, probably we need to look at the evidentiary issues. Professor van der Weydt, do you want to react as well?
Yes, maybe I'm a bit of an old-fashioned criminal lawyer, hailing from the civil law culture, and but we have noticed it's vacillating between the collective and the individual dimension time and again, and I'm referring to the comment by Professor Fausto. Then there was the hate at the collective, and then we turned again because of the dissatisfaction with that particular approach to the individual, and that's too narrow, etc. So we have to figure out whether we can find some common denominator here at this point. But I think that especially the German dogmatic, perhaps I'm indeed very old-fashioned, offers very interesting tools and very sharp tools. And I always tell my students, well, I can understand that the JCE is the favorite toy of the prosecutor because it serves as a kind of blanket, yes? All that are in one way or another involved, and that is perhaps a kind of laziness. And of course, we must come up, and I agree with you, Volker, that this criminal law enforcement is especially important as well. So we cannot afford to be so choosy now and then, but still, from a normative point of view, I prefer this more specific and surgical operation.
Thank you again for recalling the importance of German dogmatic. Maybe the last word should be given to Georgia Stephanopolou if she wants to add anything to the debate that has taken place.
No, thank you, I'm fine. No further comments from my side. Thank you.
Thank you very much. Well, I think that, I mean, unfortunately, we have now to cut our debate. There will be maybe time at the end of the day. And there are so many, at least open issues, in my view, that will deserve more attention. Thank you again to the organizers for having this, for giving us this opportunity to think all together about such, still open issues. And the organizers will actually, there will be a coffee break right now, and we will have not more than 15 minutes of coffee break. So we will meet here again at 35 past.